Good Sunday. It's Jen the Liberty Lion, and we're going to talk about positive law. Just like my video that I posted yesterday, I'm going to go over some information that's the same, some information that's new, and we're going to talk about positive law or policy. So I want to bring up to you these videos, and you can find them online in different places, and they've been around for quite a long time. And these are the videos where you see some of these IRS agents, the ones that carry badges and guns, the investigators, that talk about how they've never seen a law for taxes, a tax law. Well, I guarantee you that upon being hired, one of the first things they're given or told where to find online is the Internal Revenue Code, right? So that's Title 26, Internal Revenue Code. So if there's a title and it's Title 26 and they're given a copy or told where to find it, why do these agents come out and say, well, they've never seen a law? If they have a copy of Title 26, isn't that the law? If it's not the law, then where is the law? Where is the tax law? So we can look at the Constitution and say that that's a tax law. Okay, that's a tax law. In the Constitution, there's a right, a positive right for the federal government to tax. Tax who? Well, we don't know. Well, we know, but we think we know, but it's not what we think, right? Which is what I went over yesterday as far as the enacting clause. And the enacting clause tells us not just what law there is, but who the law is for. So the enacting clause and the Constitution and the positive law and policy is what we're going to be talking about today, and they're all tied in together. So yesterday I went over authority and the enacting clauses and the two different enacting clauses and how they work. So if you haven't seen that video, go watch this one. And then it's sort of briefly mentioned in some of these papers that I'm going to go over today. And she's listening to music in the next room, so I'm hearing music while I'm talking. So as far as authority goes, de facto, de jure, what authority belongs to who and who they have authority over and where they have authority over, which, as you probably know, is jurisdiction, and the laws of that land specifically, and then laws over all the land generally. Okay, so there's like not really any good place, I think, to start other than maybe defining positive law. So yesterday I went over the enacting clauses, and I said, we the people of the United States of America and Congress assembled is one enacting clause. And it's an enacting clause when the states convene together as a Congress, and then they give laws to the United States, and then the United States passes those laws for its people, its citizens, its servants, and it's called the United States and Congress assembled. But then we have there's one thing I forgot to print out. We have presidents that sign executive orders, and sometimes on these executive orders it'll say this order confers no rights, no new jurisdictions, no duties, no obligations, so on and so forth. And that is an indication of something being a policy, even though it's called an executive order, which is, like we've said in other videos, some way of deceit, right? So, some way of being deceitful. And we saw Trump, speaking of deceit, because the military is allowed to be deceitful. You would think that they would not be allowed to be deceitful against their own citizens, but of course they are, the military, that is. And let's find that, the Trump paper that I showed yesterday, where he is, he's got a statement. He's got a statement of something that appears to be just the president making a statement, but he says he's making the statement as the president of the United States. So the president of the United States has a title, and that's commander-in-chief. So the title, the president is the president, office of the presidency. So it's an office. It's a de jure office. And there's two titles that he has in his de jure office as president. It's executive of the United States of America and commander-in-chief of the United States. So the president has two titles, executive and commander-in-chief. So he's executive of the United States of America, which is over the United States, right? So he's the executive, but he's also the commander-in-chief. So he's above commander-in-chief, and he is also commander-in-chief. So he's above all the states, the United States of America, and he's above the United States, which, if you look at it at face value, is just the military. The United States is just the military. So the president, he signs this paper, or he has this statement. He says, President of the United States, by authority vested in me by the Constitution and the laws of the United States of America. So he's doing this as commander-in-chief. Now, on a lot of executive orders, like I said, it says it doesn't confer any rights or privileges or immunities or duties. It doesn't create any extra thing because he can't make law. So these are policies. Okay, so we're going to go over positive law. Okay, so this is, some of these I only have cutouts, like screenshots of the page of the thing that I want to highlight. So I don't always have the reference, but oftentimes you can take the sentence. So I encourage you to screenshot if you want the reference, take the sentence or the paragraph or several sentences, type it into Google, and usually something comes up, the book or something comes up. So this is Glossary of Technical Terms, Phrases, and Maxims of the Common Law, page 246 of 322. Okay, positive law. Okay, law enforced by a sovereign political authority. That is in the Constitution. The sovereign political authority were the people. The people took a vote to ratify the federal Constitution. The federal Constitution was then ratified. However, ratification did not create a new state only to replace the old state. The republics, it worked alongside the republics, or the commonwealths. They both exist at the same time. Okay, sovereign political authority, and the ratification of the federal Constitution was to give authority to the federal Constitution and the federal government, because each state retains its sovereignty, freedom, rights, powers, and jurisdictions. So when the federal government does anything outside of the Constitution, they're creating a new office, but this new office is not a constitutional office. It's a de facto office. It has no authority, and this is where they make their policies, and then they publish their policies and act as though these policies are law, and they're not. So remember, the agents came out, these IRS agents came out, and they said, well, we've never seen a law. Well, how can you never see a law if you have Title 26? Because the thing that indicates to people, that special symbol, that special thing, those special words, is missing off of Title 26. It's not there. So without it being there, there's no way to properly cite it. And with no way to properly cite it, we can't say that it's a law. And it wasn't given the citation because it didn't pass the constitutional dictates to have been called a law properly. Okay, now there's a lot of confusion around this word positive or positivism. We're not talking about all the other positive things. We're not talking about positive, negative. We're not talking about moral positivism, legal positivism. We're not talking about philosophical positivism, theoretical positivism. We're talking about what's in the Constitution and the positive things that the government can or cannot do in the Constitution, and that those things that they write have passed the requirements, and so it's stamped saying this law has authority, so we know this is a law. Title 26 doesn't have that special stamp on it. There's no way to properly cite it. It's not a law, and the agents have come out and told us. They've come out and told us they have not seen the law. They can't find the law. They can't find the law because there isn't one, because Title 26 is missing that special stamp. A lot of titles are missing that special stamp, and we think they're laws because they're in titles and they're given a name. You know, Title II Congress has no positive law citation, and it can't be called a law, and it's not coming from an authority that was ratified by the people. Okay, it's coming from some de jure office that looks like the Constitution, but it's not. So, law enforced by a sovereign political authority. That's the actual constitutional offices that were created by the Constitution that the people voted on and ratified. This created a federal state, and the federal state is confined to the federal lands other than what the federal government is to do on the federal lands for the states, like pay the debts. It's still done from the seat of government. Distinct from laws of honor or laws of nature, etc., like policy or other de facto offices, okay? Because like I said, not everything that comes out of what appears to be the federal government is not constitutional law and has no special stamp on it. There's no indication to us that has been passed into law. Now, they like to confuse us with words, and they like to say things that aren't true, and they like to write confusing things when they're describing things, but we can't look at those things and take them as facts, because like LaRue says, constitutional law as fiction, narrative and the rhetoric of authority. Okay, they pretend to have authority and they have very little. So positive law, law enforced by a sovereign political authority as distinct from other things. So constitutional law, in this case we're talking about the federal government, and constitutional law separated from other laws or policies or social norms or social contracts. Okay, so that's the most basic definition that we can get to. And so how does the government tell us that it has passed a law? Well, it's a little bit confusing because legislation comes from Congress. So the federal legislation is supposed to come from the federal Congress called Congress of the United States. And Title II Congress is not a law. So Title II Congress is a de facto office, not a constitutional one. And so the things that they write and put out to pretend our laws are just policies, right? They're just agreements between the states and the federal government. And they're not actual laws. So definition of law, Chapter 1, Part 1. I don't know what this is from. It's from an old book. Like I said, I just screenshot things. I do it for myself. So if you want to screenshot this and then type it into Google, probably something will come up. Okay, it says 1, the matter of jurisprudence is positive law. Jurisprudence, the law as conservation, the law is conservative, the law is prudent. Okay, so it's saving, it's keeping, it's fair, it's right. Okay, so jurisprudence is positive law. Okay, so we see in the United States Code that the federal government has passed a law in Title I, not Title II, that indicates to the courts what is and what is not a law. And I've read that several times. I've got it in here somewhere. Okay, so the matter of jurisprudence is positive law. Law, simply and strictly so called, or law set by political superiors to political inferiors. The superiors are Congress and the President of the United States, and their inferiors are the public servants, such as the military and civil servants and anyone on federal lands. The states are not federal servants. The federal, or the United States, is the servant of the United States of America, and that is so because the states created the United States of America. Remember what Napolitano used to say? Did the states create the federal government, or did the federal government create the states? Well, the states created the federal government. It's right there in the Articles of Confederation, where the states got together and they wrote the Articles of Confederation, and in the Articles of Confederation they created the United States, which is its servant, its creation, and what you create you control. Okay, but positive law is often confounded with objects to which it is related by resemblance, and with objects to which it is related by the way of analogy, with objects which are also signified properly or improperly by the large and vague expression of law. So positive law is actual authority, actual law based on our situation, the situation of our federal government, the United States, based on the Constitution, and as Donald Trump says, laws of the United States, because the United States of America, laws of the United States of America, not the United States, because the United States of America makes laws for the United States. It can make laws outside the Constitution, usually in a temporary capacity. And these are separate from policies. So policies are de facto, and law is positive law and is constitutional. So it says here in de facto officers, under this book, again, this was just my own notes. Office purporting to be created by constitutional law. Public officers. Who are public officers? I'm going to show this to you real quick. Okay, so screenshot that if you want and give it a Google. Office purporting to be created by unconstitutional law. Okay, policies, social contracts, social norms, all those kinds of things, right? Things that don't have a positive law citation. It has been held that the incumbent of an office purporting to have been created by an unconstitutional statute is not an officer de facto, because there can be no officer without a corresponding office lawfully existing, and an unconstitutional law can create no office whatever. So here he's saying that there is no such thing as a de facto office, because the Constitution does not give authority to create a de facto office. So if policies are creating a de facto office, the de facto office then does not exist because people in constitutional offices cannot create unconstitutional things, because there's nothing in the Constitution that allows policies or social norms or social contracts to be created by those people in those offices. The Constitution does not give them authority to do that, so they can't use their constitutional office to create a de facto office. There's one writer in one book on habeas corpus, and I have been looking mercilessly through all my stuff to find it, and I cannot find it, but I remember what it said. And it says, let's see if I can explain this right, see if I can find my words, that when a person gets into a constitutional office and they do an unconstitutional thing, the power of that constitutional office is turned off, like a light switch, it's turned off, and they don't have the power to act. It's an elliptical situation, he called it. The power to act outside the Constitution in a constitutional office is turned off. But when they act inside the Constitution, the power is turned back on. And maybe this is why Title II Congress has never been enacted into positive law, because they are not a constitutional office. So they go and they sit in these offices, and this is a de facto office, but it's not created by a constitutional office, which means it doesn't exist anyway. Okay, I don't know if you can understand that or not. Give it some thought. Okay, so an unconstitutional law can create no office whatever. So to create a constitutional law, you have to sit in a constitutional office. To sit in a constitutional office is to follow the Constitution. To follow the Constitution is to not do unconstitutional things. Otherwise, you remove yourself from the power of the office. If you remove yourself from the power of the office, whatever you're doing, you have no authority to do. So the courts have gone so far as to hold that when the law creating an office is declared unconstitutional, such decision has a retroactive effect. And the office is to be regarded as never having had any existence whatever. But on the other hand, it has been held that until the act creating an office is judicially declared unconstitutional, a person occupying such office is an officer de facto. Okay, I don't know. Figure that one out. Okay, so let's see. Let's see what we have here. I think this would be a good time to talk about what the law says about Okay, this is 1 USC 204A. Okay, talking about positive laws, talking about constitutional offices, positive law, what is a law and what is not a law. The IRS agents, some of them came out and said they've never seen the law because it doesn't exist, and it doesn't exist because it's passed by a Congress that doesn't have constitutional authority. It's doing things outside the Constitution. It's basically passing policy. They have no authority. They're passing basically laws of contracts and then getting you to sign all these forms voluntarily, which I have all this in here in my papers here. And when you take these to courts, you're taking them to a court where the judge is not sitting in a constitutional office. So this judge can say, oh yeah, it's constitutional, but it doesn't matter what he says because he's not sitting in a constitutional office. He can say, yeah, Congress said we can do this. Well, what Congress? The Congress that's passing policies or the Congress that's passing constitutional laws? So you can say Congress said you can do it, but what Congress are you talking about? The Congress without constitutional authority or the Congress with constitutional authority? And since, as LaRue says, the Constitution's not actually taught to judges and lawyers, they teach case law. They don't read the Constitution. How are these lawyers and judges, when you bring up the Constitution to them, how do they know what the hell you're even talking about? They don't. They're just going off other court opinions. So says LaRue, and constitutional law is fiction. So 1 USC 204A says, has, some stuff, you can read it. You can go out on the internet and you can read it. It says, provided, however, okay, so this is now talking about federal judges, not judges sitting in offices created by policies, such as Title 26. The IRS courts are created by policies, and those judges are sitting in political positions or positions of policy, positions created by policy. And that's why we were talking about why we said that you would maybe want to do a habeas corpus and have your case removed from that political or policy court and taken and put in front of an actual federal judge, where a federal judge would then say that it's unconstitutional. And like we said in this document on officers, where'd that go? This document on officers, and just ignore my notes here, that it's de facto, that these people have no authority, that's unconstitutional. So you have it removed, you're using habeas corpus. Now originally, habeas corpus means bring forth the body, and then Napolitano was talking about some of these people under Title VI, domestic security, which within domestic security is the Homeland Security, and Homeland Security was rounding up these college students based on their speech and what they were saying, and imprisoning them, sending them to jail or whatever. And then Napolitano had said that some of these lawyers were trying to have the case removed from the courts created by the Homeland Security Office, in which the judges work for Homeland Security, and have him brought before actual federal judges. And then in another video, it was as if he was backpedaling and saying that the definition of habeas corpus that the attorneys used was, I don't even remember what it was. It didn't sound like bring forth the body. So I don't use definitions created by lawyers or law schools or recent books. I use definitions in books that were written around the time of the founders, right? And it's hard to find some of these books, but they are out there. At least, try to get as close as I can to that time period. So it says provided, and again, 1 USC 204, codes and supplements as evidence of the laws of United States and District of Columbia, citation of codes and supplements. So provided, however, that whenever titles of such codes shall have been enacted into positive law, the text thereof shall be legal evidence of the laws therein contained in all the courts of the United States. So remember, Title II Congress has no positive law citation, and yet they are the ones passing these titles and calling them laws when they're not really laws, they're policies. Okay, United States is several states, territories, insular possessions of the United States. So this Title 1 is where this is at. Now you would think that if Title II Congress, without the positive law citation, had passed this, that this would be in Title II, but it's not. It's in Title I, because Title II is not a positive law. So they're not going to put a positive law inside of a title that's not a positive law, okay? Because we're separating law and shit, junk, trash, okay? Pretend law, fiction. Constitutional law is fiction, right? We're separating fact from fiction, LaRue's book. Okay, so in this code, 1 USC 204A, it's saying that it has to have a positive law citation, it has to be enacted into positive law, and once it's enacted into positive law, then that is the evidence that the law's been made. And so positive law cases go in front of actual federal judges when it's a federal positive law, and the trash goes in front of these judges created by the policies. So like Napolitano said, the Department of Homeland Security has created positions for its own judges, and it hires its own judges, and it's hearing cases as if they were federal judges, and they're not. So these people that have been jailed by these non-federal judges under policy or social norms or whatever you want to call it, contracts, the attorneys are having these cases removed from those pretend judges, those fake fiction judges, in front of trying to get the cases in front of actual judges, and they're using the writ of habeas corpus, which is called the extraordinary writ. Okay, let's see what else you got here. Okay, so I talked about these things being contracts. So let's see, title, I don't remember the title, Aliens and Nationality. It's not been passed into positive law. That means it was passed by Title II Congress, which is not an actual Congress. It's not a constitutional Congress. But since there are policies or social norms, social contracts, I like to call them social contracts because it makes more sense since they actually have you sign papers. So to become a national or whatever people want to become when they come to this country, get their green card or whatever, they're signing papers. When you get a job at a corporation, you're signing papers. When you go to get your driver's license, you're signing papers. When you go to do anything under these social policies, you're signing papers, which means it's a contract. And once you make it a contract, it's a contract for you and you individually, and then you're under that contract. So once you sign the papers that have the Title 26 on it, you're making it a contract for you, and that's why you're giving them authority to do the thing that you don't want done to you. That you're saying, well, this is not constitutional, this is that, how are they doing this? Well, because you signed the papers, you let them. Now, we can talk about how we're trapped in this system, and that's cyclical and it gets us nowhere. And I understand that we are trapped in this crazy screwball system where we've been, in a way, forced to give up our rights so that we can have a job, so that we can buy a house, so we can do all the things that normal people want to do. But we do it because we sign these papers, and we give up our rights. So Austin, in his book on sovereignty, A Brief Introduction to Austin's Theory of Positive Law and Sovereignty, he calls signing the papers your positive mark. So I individually give my positive mark when I go to a bank and I ask for a loan so that I can buy a house or a car or get a credit card or open a bank account or whatever. I'm giving my positive mark. When you sign, you're giving your positive mark. That then turns it into a positive law, not that it makes it constitutional, but that you're agreeing to it. And so you've made it a positive law for you. Okay, so, but jurisprudence has to do with the law, which is enforced within the state. And it would seem, therefore, that the possession of the positive mark is more essential test for purpose of jurisprudence. And that a certain degree of dependence in external matters is quite consistent with sovereignty from the point of view of the jurist, so long as the power of making laws and the power of administering them are exercisable wholly and exclusively by some determinable body within the community. There seems to be all that is strictly necessary from the standpoint of jurisprudence from the complete conception of sovereignty. Okay, your signature, this is your signature. But this is also sort of like the actual federal government signature in its offices, its constitutionally created offices. It's sort of like its signature when it puts the positive law citation. He also talks about the negative. Can a man be subject to himself? Is this it? A power over a person which cannot be exercised without that person's consent is no power over him at all. A person is subordinate to a body of which he is himself a member only if that body has the power to act, notwithstanding his dissent. So when you join the military, you're signing a contract. As an enlisted person, you sign a contract and you become a member of the United States. When you are a commissioned officer, you receive the commission, you take the commission, you start acting the part, and you are a member of the United States. When you are elected and you accept the position, you become a member of the United States. When you apply for a position with the government as a civil servant, you're accepting the position. So you become a member of it, and as a member of it, you're under its authority. Okay? You have to sign. You become a member of it. So when you start signing all these papers to pay taxes, to get a driver's license, you're signing, you're making it a positive law for you to become a member of a political society such as the social contract, which is based on policy. So he does talk about the negative mark. It's positive. Maybe it didn't print out. Let's see. Legal meaning of the word sovereign, by which it means that that person or body in the state which has the supreme lawmaking power. The word sovereign is used without any qualifying adjective. It must be taken in its legal signification. The bulk of the given society must be in the habit of obedience or submission to a determinable common superior, whether that superior be an individual or a certain body of individuals. This he calls the positive mark. The superior person or body must not be in the habit of obedience to be a determinate human superior. It may render occasional obedience, but it must not render habitual obedience. This is the negative mark. These two marks must, in Austin's view, coincide before there can be sovereignty or independent political society. So there's two things going on here, I think, in our situation, applied to our situation, and that's that without the special mark, the positive law citation, actual federal judges sitting in constitutional offices cannot see it as a law. But when policy creates a position for a non-federal judge administering or interpreting policy, it's because the thing that brought them there, the title or the contract or whatever that brought them there, the policy that brought them there, has the or doesn't have it, but there's a negative mark, meaning the mark is missing. So it can't be brought to a federal judge unless, of course, they use the extraordinary writ, which is the writ of habeas corpus, according to Napolitano, if I'm understanding Napolitano correctly. So policies are negatively marked, or they're missing the mark. They don't have the mark. But also, if you don't sign the papers, you're not giving it a mark. And so it's a negative mark. There is no mark. You can't prove something's there if it's not there. You can't prove I was over there if I was never over there. So it's called proving a negative. You cannot prove a negative. If you don't sign the papers, there's no proof of it because there's no positive mark. Just like on a title without the positive mark, which is the positive law citation, it's negatively marked. There's no mark on it. It has no positive law citation. There's no mark. There's no proof of it. It hasn't been made a law. Okay, so I think I read these all to you. And let's see, this says, this is History of the Science of Politics, the Middle Ages and the Renaissance. This is page 59. Frederick Sir Pollock from archive.org. We now come to Hobbes, with whom the modern school of political theory begins. Political theory. Aristotle effected the separation of ethics from politics. From Hobbes, or rather through Hobbes, we get further separation of policy from legality, of that which is wise or expedient from that which is allowed by positive law. So policy being wise or expedient, and legality being positive law. Same book. Page 109, he's talking about it remained to complete the separation of theory of political sovereignty from that of the ethical or historical foundation of political society. This was done by John Austin, who finally cleared the way with labor, which now seems uncouth and excessive to the conception of a pure science of positive law. The worker in this field assumes the sovereign authority of the state as, for his purposes, the ultimate source of laws and legal institutions as they exist. And he goes on, you can read that yourself. We've got positive prejudice in their favor, but because they dread the unknown, they cling to any tolerable certainty for certainty and custom's sake. And when they break loose from their accustomed order, it is a vehement presumption that their present state is not only imperfect, but intolerable. Same book as the last one. Okay, we see that it in assemblies empowered to act by positive laws. Okay, that's federally, that's the constitutional offices empowered to act by positive law. So federal judges hear cases that are constitutional. In policy, judges in positions created by policy do not hear constitutional cases, as far as I know. They hear policy cases. But to us, we think that they're all the same, and that the Department of Homeland Security, who created positions for judges, I think Napolitano said some of these judges don't even have law degrees or Juris Doctorates. They don't even have Juris Doctorates, so some of them. So they're hearing cases, they're just hired. They're like civil servants hired to hear cases, and they work for the Department of Homeland Security. They don't work for really the federal government. And the Department of Homeland Security, again, under Title VI, domestic security, has not been made positive, which means it's been passed by Title II Congress, which are not constitutional, which is not a constitutional Congress. Even if it says, you know, the Congress of the United States, blah, 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 and looks like a federal Congress, it's not a federal Congress. It's a political Congress. It's a political situation. Okay, so where no number is set, that positive law which empowers them, the act of the majority passes for the act of the whole, and the course determines as having by the law of nature and reason the power of the whole. Positive law. Okay, another definition. Positive law. Law actually and specifically enacted or adopted by proper authority for the government of an organized jural society. So in our Constitution, the Constitution was ratified by each state individually. Why? Because the Articles of Confederation said each state retains its freedom, sovereignty, independence, and all rights, powers, and jurisdictions not given to the United States, which was very little bit, which were the absolutely necessary things that the states needed to have done. And their promise, the states promised to fund it constantly, right? You can look that up if you like. It's just another definition. Okay, the Modern Legal Philosophy Series, Volume 4, 1922. This is from archive.org, but the book looks like it came from Hathi Trust Digital Library. This is the introduction, Theory of Law. Let's see. Principles of Logic and Metaphysics, 1894. Although the philosophy of law in its latest form has turned towards the explanation of positive law, it is nevertheless not to be confused with the science of positive law. So we have different types of positive law, okay? That's, I think, my point in here. You have positive philosophy, positive science, you have positive and negative in law, and we're not necessarily talking about that. We're talking about how something conformed positively to the Constitution. It went through a series of tests, and it complied with the mandates of the Constitution. Now, federal judges do not interpret the Constitution, they administer the Constitution. That's what they're supposed to do. The first judicial act in the oath said that they are sworn to administer the Constitution. So when you have policies created by a Congress not sitting in a constitutional office, you cannot have the federal judges interpret those policies because they can only administer the Constitution. So the extraordinary writ, habeas corpus, you're supposed to get these cases, according to Napolitano. What he was saying that the lawyers were trying to do was have these cases removed from like the non-positive law, the policy, the positions for judges created by policy to positions created by the Constitution. But those judges in constitutional offices will probably throw it out because they don't have the authority to hear it. And if they do have the authority to hear it, they're going to call it unconstitutional. So if the government wants to keep its power going, they're going to keep these cases from being heard in front of federal judges, because the federal judges will throw it out or call it unconstitutional, in which case I think it would have a ripple effect and the dominoes would start falling and the power would be diminished. I think Trump has no choice but to start getting control of these programs, because the more we find out about the fraud and the deceit and the manipulation, the more quicker the dominoes are going to fall, and that may end up hurting a lot of people, including government's future usurpation of power. So if we remain stupid, then they can just wait a while and start it all over again. If we're onto them, then we might, stay vigilant because we'll know the game. So this, I don't know, you can screenshot and type this in Google. When this definition is applied to positive law in the historic development, a different meaning is given to it. Legal rules are then considered as logical consequences of the principle of liberty because they are all, in one fashion or another, delimitations of human liberty, establishing its boundaries, measure, and restrictions, and in this sense forming norms of liberty, customs. Let's see. What's legal? I think West's Legal Dictionary, positive law. I don't know what volume this is or what edition. From archive.org. Law actually and specifically enacted, okay, or adopted by proper authority. Okay, Title II Congress is not proper authority. If you go on to the OLRC, Office of Law Revision Council, where they have Title II shown, it doesn't have a positive law citation. So anything passed by the Congress under Title II that doesn't have a positive law citation is not a law. So it's just policy. Let's see, back to General Theory of Law. Korkanov, is this right? I think this is the same as the last one. The Modern Legal Philosophy Series, Volume 4, 1922. Without being able to claim to give a complete solution to these questions, positive law, to the extent which it involves them, is compelled to find some solution for them. The lawyer must ask, what are the conditions of the validity of contracts? The signature, right? That's the validity of the contract is the signature, and all kind of lawyery things in there. But once you sign the contract, you're making it, you've given it your positive mark. Okay, if you don't sign it, there's no mark. They can't, what are they going to do? There's no signature. Okay, so on impeachment, this is about, I think, the states being able to impeach. So the states have the authority and are given the duty to impeach impeach those people that in the service that they created, or the agency that they created, or the military. So the United States. So the United States of America, or I guess individual states even, could impeach an officer of the United States. So we define on impeachment, therefore, an impeachable high crime or misdemeanor to be one in its nature or consequences subversive of some fundamental or essential principle of government, or highly prejudicial to the public interest. And this may consist of a violation of the Constitution, of law, of an official oath, or of duty, by an act committed or omitted, or without violating a positive law, by the abuse of discretionary powers from improper motives, or for any improper purpose. Manager Butler adopting Mr. Lawrence's determination, 1 trial of the president, 88. Butler's definition, section 433. And again, I don't have the reference to this book. You can just Google that. Positive law. Again, law actually and specifically enacted or adopted by proper authority for the government of an organized jural society. International law. Okay, let's see. Okay, this is not supposed to be in here, but this is for the word individual, which nations are considered individuals. Any group can be considered as individual when it's acting as one body. Okay, so in order, therefore, to determine the province of jurisprudence, it is necessary to obtain a comprehensive and rigorous definition of its subject, namely positive law, to distinguish positive law from objects to which it is related by resemblance or analogy, and which are signified properly or improperly by the large and vague expression law, is the purpose of the work originally published by the author under the title of The Province of Jurisprudence Determined, corresponding to the first 6 lectures of the series as now published. It would be out of place in this brief abstract to attempt an outline of the method adopting in arriving at the requisite definition. Briefly, positive law may be described as consisting of commands set as rules of conduct by a sovereign to a member or members of the independent political society wherein the author of the law is supreme. Okay, so the states they sent deputies to write the federal constitution. The federal constitution created an independent body, the military, and the people in the military are the only ones subject to that body. Okay? So reading the definition, he has again commands set, which is the Constitution, as rules of conduct by a sovereign, the states, to a member or members, the people in the United States, the independent political society, the military, wherein the author of the law is supreme. Okay, the United States is supreme, and it's supreme over the military, and the members of the military are subject to that political body. So people in the states are subject to state legislatures. The states together are creators of the United States, and so the United States is subject to the United States of America, but the members in the military are subject to the United States. The United States of America does not make laws for each individual state because each individual state retains all of its rights, and it only gave rights to the United States when it created it. Okay, I think I read this. This is interesting. This is just a little table, and this is in Austin's book on sovereignty, A Brief Introduction to Austin's Theory of Positive Law. And it separates between laws proper, law of God, human laws. Under human laws, we have positive law, or laws strictly so called, which in our society are constitutional laws, and laws set by men not as political superiors, nor in pursuance of legal right, such as policies, I think, or cultural norms. And then on the other side, we have laws improperly so called, laws by analogy or laws by metaphor. Okay? This table is taken from W. Jethro Brown, The Austinian Theory of Law, page 4. Okay. Let's see if Clinton wrote that statement in his... This is Executive Order 13132. Okay. So he says, this order, this is what I was talking about before, like policies versus actual law and so on and so forth. It's called an executive order, but it's called an executive order, but then they say, well, it doesn't really mean anything. This order is intended only to improve the internal management of the executive branch and is not intended to create any right or benefit, substantive or procedural, enforceable at law by a party against the United States, its agencies, its officers, or any person. William J. Clinton, 1999, 13132. 13132. There's also 1313. Okay, this is just a statement on the executive order on federalism. As a former governor, I know how important it is the American people that the federal government and state and local governments work together as partners. The executive order on federalism I signed will strengthen our partnership with state and local governments and ensure that executive branch agencies are able to do their work on behalf of the American people. I want to thank the representatives of state and local governments who work with my administration in developing an executive order that enables us to better serve all of the American people. And this is, I think, from 13134, Appendix D. Statement on the executive order on federalism. 13132, federalism, that was Appendix D. Okay, and I think that is all we have for today on this video. And if you have any questions, as always, like, share, subscribe. Please consider posting this video on Facebook, on, I don't know if you can do Instagram or TikTok or any other social media platforms you might have. If you use the link to this video, it'll lead people directly to here. And it doesn't just help this channel, it helps all of us understand what government is and what it is not, and the nuances of the legal system and the political system, which is politics and policy. I think I thought I had a definition here. Policy and politics are the same, and policy and politics are not what the government's supposed to do. They're not supposed to be politicking. They're supposed to be administering the federal Constitution and the laws of the United States of America for our benefit, and not to be used against us to enlarge government and make their corporate buddies wealthier. So again, like, share, subscribe. I really appreciate it if you share the videos on your social media platforms, and I'll see you in another video.